In South Africa, no one can be evicted without a court order. Here's the roadmap and how to protect your rights. I'm Simon Dippenaar, attorney and founder of SD Law in Cape Town, Johannesburg and Durban. I've acted for both landlords and occupiers in matters ranging from simple lease disputes to complex cases involving municipal housing duties. In this video, I'll give you a clear starting point: the law that governs evictions, the roles and rights of each side, and the common mistakes that delay or derail cases. What the law actually says. The Constitution, Sections 26, housing rights. Courts won't allow arbitrary evictions. The test is just and equitable. The PI Act governs evictions from homes or land. Sections 4, the standard process, including Sections 4.2 notice authorized by the court and served by the sheriff on the occupier and the municipality at least 14 days before the hearing. Sections 5, for urgent evictions, an exceptional remedy for danger, hijacked buildings, or serious prejudice. Timeframes can be shortened, but fairness still applies. And the Housing Tribunal is free and useful for rental disputes, but it cannot grant eviction orders. Only a court can. ESTA applies to certain farm or rural occupiers. Now the roles and rights. Landlords have the right to cancel the lease lawfully and reclaim property through court. They may claim arrears or holding over damages. Tenants or occupiers have the right to due process and a fair hearing. Self-help lockouts, changing locks, cutting electricity or water are unlawful. Courts restore possession through spoliation and often penalize this conduct. When children, the elderly, or people with disabilities are involved, courts may involve the municipality and consider alternative accommodation to ensure the outcome is just and equitable. Now the process overview. Here's the roadmap from start to finish. Cancel the lease or notice to vacate. That's a valid written notice. Issue the court application in Magistrates Court or High Court. Then you have a court-authorized PI Sections 4.2 notice. The court approves the form and manner. The sheriff serves it on the occupier personally and the municipality no less than 14 days pre-hearing. Then we have affidavits, the founding, answering, replying ones, including any vulnerability in municipal engagement. Then the hearing. The court applies the just and equitable test and may set humane vacation dates. Then we have the order and writ of ejectment. If no voluntary vacation, the sheriff executes. Lead times vary by jurisdiction. Myths and mistakes. Myth 1. I can change the locks. No, that's unlawful and backfires via spoliation. Myth number 2. The tribunal will evict them. No, the tribunal can't evict, only courts can. Mistakes 1. Poor paperwork. No valid cancellation, no arrears schedules, no photos. Mistake 2. Ignoring the 4.2 notice. You must respond, especially if there's vulnerability or risk of homelessness. When urgency applies. Urgent eviction, PI Sections 5, is reserved for exceptional cases, danger, hijacked buildings, criminal activity, or serious prejudice. The court may shorten timeframes, but we still need proper affidavits and a fair outcome. What to do next? Evictions are stressful, but they're also predictable when you follow the law. No court order, no eviction. If you're a landlord, act lawfully and keep records. If you're an occupier, don't ignore court papers. Raise relevant facts early. Download my free eviction playbook, a one-page checklist for 7 steps, documents, timelines, and traps to avoid. And if you need clear advice now, book a consultation with me at SD Law.